I'd like to welcome you all to the North Carolina Department of Transportation and the Division of Motor Vehicles formal public hearing on the proposed rules changes, or really the proposed adoption of a temporary rule, which is of the Chapter 19A of the North Carolina Administrative Code, Subchapter 3K. 01, Section 0101 and Section 0102. My name is Jamil Robbins. I am the Public Involvement and Community Studies Group Leader with NCDOT, and I'll be your moderator for this evening's hearing. Now, I would always like to start with some ground rules and some housekeeping. These are formal proceedings. They are being recorded. So I would ask that you please turn your phones to silent as not to interrupt the recording. Restrooms are outside the door, and you hang a left by the gym. You go down that hallway adjacent to the gym. The restrooms will be on the right. As far as ground rules go, I really only have one rule, and that is the golden rule. That is to treat each other as you would like to be treated. And that's important in a forum such as this because you may have differing opinions, and so if someone gets up to speak during the public comment period that you disagree with, I ask that you not helping them from the crowd or make loud gestures or sounds. So if we do that, we treat each other with respect, we'll have a nice, orderly, and civil meeting. And the other thing is, we want to keep in mind is not to shoot the messenger. That's a good adage that I want to remind everyone of too. So with that said, I will go ahead and get started with the purpose of tonight's public hearing. Now, tonight's public hearing is just an opportunity for you, the public, to be part of the rules-making process. Specifically, tonight we want to solicit your input on the request to adopt a portion of the North Carolina Administrative Code. And your participation in this process is greatly encouraged. And you participate by making your comments heard, either verbally tonight during the public comment session, or by submitting them in writing. And you can do that. There's an attached comment sheet that is strategically placed as the last page in the handout, so you can just rip it off. You can fill it out, rip it off. The return address is on the back. You can fold it down, staple it. You don't need an envelope. You can just put your stamp on there and mail those in. You can also email comments to myself or Ms. Helen Landy, who is at the sign-in table. Our information is at the bottom of that comment form. And you have until October 3rd to get those comments in to us. So what is done with the input that we receive through this process? Well, once the public comment closes on October 3rd, then agency staff will review all of the comments that have been received during that time and make a decision on whether to adopt, well, we will move to adopt those temporary rules. Once we adopt those rules, we will submit it to the Rules Review Commission at the Office of Administrative Hearings, and a link to the Office of Administrative Hearings website is on our webpage. Once that is done, the Rules Review Commission will either approve or not approve the rule. If they approve the rule, then they go into effect January 1st, 2018. If they do not approve the rule, the agency will work with the Rules Review Commission to address their concerns. Now, during this process, if someone submits questions that require a response, we will prepare a response to that person. Now, the next 2 pages are the actual writing of the law, but I'm just going to go over the summary of the law. The first page you'll come to, though, is a summary of all of the fees. But we're here tonight because this is a mandate by the North Carolina General Assembly that requires the Division of Motor Vehicles to collect fees for administrative hearings on or after January 1st or on January 1st, 2018. These fees are required for hearing requests that review the revocation or suspension of a driver's license, vehicle registration, inspection stations, automotive dealers, and mechanics. And there will be no charge for medical hearings. If a hearing is warranted, the DMV will notify the driver in writing with instructions on how to request the hearing, the applicable fee, and deadline for submitting a request. Upon receipt of a written hearing request and the required fee being paid in full, the DMV personnel will evaluate the citizen's eligibility for the requested hearing. Further action will be taken based on the eligibility determination. Now, there is an indigent clause in the law, and which affords those people living below the poverty level an opportunity to have their fees waived. And we'll talk a little bit more about that in just a second. But again, the hearings are mandated by the North Carolina General Assembly and administered by the Division of Motor Vehicles. Again, payments for hearings will begin January 1st, 2018. The hearing fees will be assessed to 19 categories of hearings that are related to the subject areas that are listed in your handout. Again, hearing fees will not apply to medical hearings. Fees will be, for the majority of hearings, will be prepaid. But there are instances where some of those fees will be paid post-hearing. And that would be for hearings that review applicants' compliance with the requirements of the Ignition Interlock program, for applicants' compliance with the requirements of the applicant's probation or conditional restoration agreement, for hearings related to violation received on a report from an Ignition Interlock vendor, and motor vehicle dealer license or sales representative license hearings for a previously issued license. Now, payment, with the exception of driver license hearings, which could be paid at the driver's license office, all other fees must be paid with the hearing request by mail. And again, for the driver's license, Ignition Interlock, automotive dealers, state inspection hearings, and franchise dealer disputes, you will mail those to the administrative support address listed below. And for liability insurance hearings, you would mail it to the address listed in your handout there. Now, if canceled 10 days prior to the hearing, a partial refund is available. It would be the amount of the hearing less $20 for driver improvement clinic hearings and for DMV service denial hearings. There will be a $50 processing fee or admin fee for all other hearings. And refunds will not be available for franchise dealer hearings. And as I talked just a few minutes ago about the indigence clause, that will be available for citizens with household incomes below 150% of the federal poverty level. And to apply, applicants must complete and notarize the DMV's affidavit of indigence form, which can be found on our website. If you want to see a chart with the relative income amounts, because it is based on household as well as income, household size, you'll see that chart listed in your comment, in your handout below. Now, the next form you'll see is a Title VI form. There's a completely voluntary form that we ask people to fill out. That will help us give us some information on the people that attend our public hearings or public meetings. We hope to use that to better serve the public in the future. And again, the last page and most important page in the handout is the comment form. Again, keep in mind that written comments carry the same weight as verbal comments. We don't want to penalize people that are not comfortable speaking in front of crowds. So with that said, we now reach the public comment portion of the hearing, which is the most important part. Now keep in mind, this is not a debate. I'm not here to debate anyone. Again, this is a public hearing. We want to hear what you have to say. So when I ask you to come up and speak, please state your name and address and who you represent. Once I've exhausted this list, we only have 2 people that signed up to speak. I will open it up to anyone that would like to speak at that point. So first we have Mr. John Policastro.
Yes, sir.
Did I say that right?
Yes, sir, you did.
Okay, good.
Thank you, Mr. Robinson. I'm John Policastro with the North Carolina Auto Dealers Association. The address of my office is 1029 Wade Avenue, Raleigh, North Carolina 27605. Good evening. Again, I'm John Policastro, General Counsel with the North Carolina Automobile Dealers Association, representing nearly 600 new franchise, new automobile, truck, and RV dealers throughout North Carolina. We greatly appreciate the opportunity to address these proposed temporary rules tonight and provide these comments. And NCADA will be providing formal written comments to DMV as well. NCADA has significant concerns regarding the level of the hearing fees included in these proposed temporary rules and the manner in which the fees are proposed to be charged. For tonight, I'd just like to briefly address 2 sets of fees in the proposed hearing rule fee schedule that directly impact the automotive industry. Hearing fees for inspection mechanics and inspection stations, in which the hearing fees in many instances exceed the level of potential fines for the violations charged, and also hearing fees for actions brought pursuant to the North Carolina Motor Vehicle Dealers and Manufacturers Licensing Law, that are known as the franchise law in North Carolina, for which the hearing fees appear to significantly exceed the level of fees found in the General Court of Justice, and which do not appear to be rationally related to the actual cost incurred by the division for such petitions. Now, NCAA fully understands the directive that the division is under from the legislature. However, many of the fees in the proposed schedule, again, do not appear to be rationally related to the actual cost of conducting the type of hearing covered. The proposed hearing fee schedule includes a $1,200 fee for just to file a petition pursuant to the franchise law, and a $600 fee for every motion filed in such a proceeding, regardless of whether the motion is substantive. Further, such fees are also singled out as the only fees that are non-refundable in any circumstance, even though these hearings are often and arguably the most common type of hearing to be canceled before any substantive work or costs are incurred by the division. Automobile dealer and manufacturer franchise cases filed by dealers with the Commissioner vary greatly in their level of complexity, the amount of DMV administrative time required, and the duration of the matter. Many of such cases are filed by dealers with the Commissioner for the purpose of preserving the dealer's rights under the franchise law. For example, to stay a proposed franchise termination or to stay a proposed chargeback of warranty or incentive payments. In fact, the great majority of franchise-related cases filed by dealers with the Commissioner are settled by the parties on their own within 6 months after the initial petition has been filed, with little or no involvement by either the Commissioner or the hearing officer appointed by the Commissioner. Based on these facts, a DMV hearing structure in dealer-initiated franchise cases, which requires that dealers pay an upfront, non-refundable filing fee of $1,200 at the time the initial petition is filed, is not at all reasonably related to the actual cost the division would be expected to incur in processing the case. The division's expected costs are more related to the duration of the case and the amount of time required for an evidentiary hearing on the merits. For these reasons, NCAC will be proposing an alternative fee structure for dealer manufacturer franchise cases in formal written comments on the proposed rules, which we feel is more reasonably related to the expenses the division would incur in processing these cases. And with regard to hearing fees and inspections matters involving inspections, mechanics, and inspection stations, again, the proposed fee of $200 for a mechanic or inspection station license hearing in many instances exceeds the actual fine for certain inspections violations. For example, for a first or second type 1 violation, the civil penalty is $100 for a mechanic and $250 for an inspection station. For a first or second type 2 violation, the civil penalty for a mechanic is $50 and $100 for an inspection station. It appears that the proposed hearing fee of $200 will discourage some citizens from seeking a hearing even if they feel that the charged inspections violations is unjust. The practical effect of a $200 hearing may very well be to eliminate hearings for anything other than a type 1 violation in which a license suspension is on the line. For other violations, even with a valid defense, the cost of the hearing exceeds the actual fine to such an extent it would not be surprising for most just to move on and pay the fine, thus putting themselves at risk of potential future charged violations which could result in a license suspension. Again, NCAC encourages the division to review the proposed hearing fee schedule and to structure the proposed fees so that they are more in line with the actual cost to be incurred. For example, rather than applying a uniform initial fee to just begin a matter, perhaps consider the complexity of each type of hearing and whether a more detailed and expanded fee structure within the hearing type may be more appropriate. For example, a lower initial filing fee with additional fees the longer the duration of the matter goes on and the more division work that is required and costs are incurred. It appears the temporary rules process will afford the division time to further adjust the proposed fee schedule in time to meet the legislative deadline for the imposition of the hearing fees. Again, NCAA thanks the division for the opportunity to provide comments this evening and looks forward to submitting our more detailed written comments on these proposed temporary rules.
Thank you, sir. Next, we have Mr. David Farrell.
Thank you. Appreciate the opportunity to be here. I'm David Farrell of the law firm of Nexon Pruitt, 4141 Park Lake Avenue, Raleigh, North Carolina, 27612. I'm here representing the Inspection Station Association of North Carolina and the Independent Garage Owners of North Carolina. These are associations that represent stations and mechanics that perform emissions and safety inspection stations in the state. We share a lot of the same concerns of the speaker you just heard from related to the amount of the fees and also the timing of payment and some of the procedural issues that relates to the fees. So just to touch on a few of our concerns, we will also be submitting written comments as well. But the amount of the fee of $200 is problematic and is discouraging of those who have legitimate defenses from raising those when it, in some cases, is 4 times the amount of the fee or the penalty that would couple with a type 2 violation. As Mr. Policastro said, for a type 2 violation, it's a $50 fine for a mechanic for a first or second type 2. It's $100 for a station. In all cases, the hearing fee to challenge such a charge would more than outweigh the actual fee or civil fine for committing the charge. So there's a disincentive there for folks to appeal those when they have legitimate defenses. And we don't believe that is what this hearing schedule should do. We certainly recognize the legislative mandate to DMV, but we also believe that the fees could be handled in such a way to meet the mandate, but then also not be a disincentive to stations and mechanics to addressing these civil fines that they're levied by DMV. We also have concerns with the timing and the procedures. The way we understand the rules to be written, the hearing fee must be paid at the time you request your hearing, which is the way the DMV process works, that's when you appeal. So an appeal of a charge also is your request for a hearing. We also understand that the current timeline to request a hearing is 10 days or a very short period of time. And so what you have is a situation where, in the way the law is written, it's not a valid request if the fine is not also paid. So you have a situation where you could have someone request a hearing. If they don't pay the amount at the time, then their hearing would be untimely and they would not be able to appeal that. We certainly believe there are things that could be done to still comply with the mandate, such as having the hearing fee paid after the hearing as a part of any order of the division. If they're going to uphold and charge a civil fine, the hearing fee could be charged at that point. There are other ways that we believe this could be addressed. We're also concerned that there is an indigent process, and as written would only apply to individuals, would not apply to any small business owners, small stations, those that might not have a high volume of inspections. These margins are close anyway for these businesses, but also the process required appears to be too great to be accomplished in a very short 10-day period of time to request a hearing. And I don't believe these hearing fees are ones that are in the small list that could come after a hearing. These are ones that have to be paid at the time. And so we believe that is an undue burden on the stations and the mechanics, given the short period of time and what the process that one would have to go through to meet the indigent requirement in order to then have a timely appeal considered by the division. So again, we certainly appreciate the mandate. We understand DMV has to address this issue. We certainly stand ready to meet with anyone to talk about these issues to see if there's something that can be worked out. But we also have concerns with these and we'll be submitting more detailed written comments at the appropriate time. But again, we appreciate you allowing us to comment.
Thank you so much. So with that, that's the list of speakers. Does anyone want to speak now? On what? Twice. All right, well, thank you so much for coming out. This will adjourn tonight's public hearing. We do have staff here tonight. If you have any questions, you'd like to get answered, talk one-on-one with staff, feel free to do so. But thank you so much for coming out. And, drive safe going home.